We welcome everyone to our meeting today, and as Matthew mentioned, we're going to pick up from where we left off last time, where we were talking about claims and disputes. We are taking a lot of this information from the CSI Construction Contract Administration Practice Guide, and specifically Chapter 10 is on claims and disputes. Jim, anything to say in a way of a welcome?
No, just welcome everybody, and I'll look forward to your input and questions. Please, as Matthew said, jump in and use that chat box. It makes the conversation a lot more enjoyable and certainly a lot more learning field for all of us.
Okay, I am trying to advance the slide and it's not advancing. And I apologize. I don't know what's going on with this computer.
Douglas, just occasionally sometimes with the GoToWebinar system, if you just want to hit the escape key and go back into the presentation, occasionally it just gets a little wonky when it tries to figure out who's the one in charge of presenting and moving slides.
Yeah, I've tried that, and the escape key isn't working either.
Okay. Well, what I'll do is I'll pull back the I'll pull back the presentation from you and give it back to you and see if that'll help.
Matthew, that's not helping. Can you just pull it up and we'll walk through it on your end?
Sure, just 1 second here. Let me find the presentation for us.
Oh, wait a second.
Oh.
Let's see if it works now. Okay, it's working.
Okay, great.
Okay, so to review from last time, we talked about contractor claims, owner claims, and third-party claims, the submission of claims, resolving and settling claims, entitlement, dispute avoidance, and we just got into talking about alternative dispute resolution, and that's what we're going to cover today. Last time, Kevin O'Bean gave us a brief update on the new EJCDC procedures for dispute resolution. And we had some comments following the presentation and some questions that we were going to address to start off with. So from last time, the first comment or question is on the screen there. I have used and suggested an EJCDC 202-2002 alternative dispute process where you meet and confer and negotiate. First, the engineer and the contractor have 30 days to meet, confer, negotiate. If that's unsuccessful, then the owner gets brought into the picture and they give it another 30-day process, and then if that's unsuccessful, then they go to the dispute resolution process. So we wanted to share that. That comes from Glenn Noble. It's the process that he's used where the designer or engineer and the contractor first take a crack at it. If they're unsuccessful, they bring the owner in. And then if that doesn't work, then they go to the process that's probably outlined in the contract about dispute resolution. He prefers arbitration. I think this is a good process. It gets you a chance to kind of sit down and sort through things. The caution I would say on this is 30 days, 60 days before you get into a dispute resolution process. Just make sure that you're not delaying progress on the project and you're not causing delays there. Anything to add, Jim?
No, what I particularly like about this is the timeline, that there is a defined and maybe somewhat shorter than we get into in other instances with other methods. So, but as you point out, Doug, if you're using this, and we're going to talk about that in the presentation, I think in the next question actually, So it may be a good segue into that about keeping momentum and progress moving on the job if you're having to do this during construction.
These were from Martin Wade. The first comment he had was, can you discuss the use of a forced account method for time and materials to require the contractor to proceed with work while a claim or dispute is being resolved? Jim, I don't know if you want to take first crack at that, if you want me to keep going.
Well, go ahead. You keep going.
The forced account method is basically what AIA documents would call a CCD. It's where you have not agreed to the cost for the change, but the contractor is forced to proceed with the work, and you work out the dispute in the dollar amounts later. So it's similar to AIA Construction Change Directive. I'm not sure if EJCDC has a similar vehicle. I know in the state of North Carolina on our state projects, what the state uses, what they call it, is a field order, where once that's signed and issued, the contractor has to proceed with the work, and then you work out the price later.
Yeah, and I'll just add to what Doug's saying, that some of the notes that I made here about public versus private work, and it may be this way in many places in North Carolina. We have this opportunity within the AIA documents and our state construction office documents to apply this method so that the progress of the project isn't held up for some arbitrary reason. One of the things that came to my mind is that in using this method, you certainly can encumber a lot of work on the firm, either the engineer or the architect, in trying to be sure that the information is accurate for time and material. You know, the tracking of labor and accounting and confirmation of those charges certainly obligates you to more than maybe you anticipated in the beginning. So it's certainly a method that works, but it can have a big impact on the designer of record.
And Martin's next question was, if a claim is filed during the process of construction and this causes the delay or stop of a certain scope of work, how can you keep the progress moving without waiting for the resolution of the claim or arbitration? Typically, there are provisions in the contract to address that. AIA 201 Section 8.2.3 reads, the contractor shall proceed expeditiously with adequate forces and shall achieve substantial completion within the contract time. So that's kind of contemplating that once you start contracting, you're going to keep working until you get to substantial completion. And then Section 8.3.1 of the AIA 201 General Conditions says, if delay is valid, then the contractor is entitled to a time extension. So if the contractor is delayed by delay authorized by the owner or pending mediation or arbitration, and the contract time shall be extended by a change order. So if you do get into a dispute and you are entering into mediation and arbitration during the course of the work, and it causes a valid delay to the contractor, then he is, according to the documents, entitled to an extension of time. And the last section I wanted to point out in the AIA 201 General Conditions is Section 15.1.2 that says, pending final resolution of a claim, the contractor shall proceed diligently with performance of the contract. So the AIA document kind of covers different situations, and it's just kind of a broad brush picture, but you can rely on any of those clauses to protect all parties. First, if there is a claim, the last section says that the contractor has to proceed with the work. He can't just stop the work, and he proceeds with the work pending final resolution of the claim. And then the section I read before that says that if there is a delay authorized by the owner pending arbitration or mediation, then the contractor is entitled to an extension of time by change order.
There are also some applications that may be an opportunity that in which the owner may take over some of the work, and of course these have other ramifications, but if, for example, they have personnel that are capable of carrying out a piece of the work, they may take over the work. They have an opportunity also under other applications to hire a separate contractor to come in and perform that work. Of course, all of those have a huge impact on what is done through the construction contract with the existing contractor, and they're not arbitrary decisions in any way, but those are some other options that may be available depending on the construction contract.
So those were some comments and questions we got from last time. If you've got, at this point, we'll take a brief pause. If anyone has anything else that they wanted to share or any questions or comments, please feel free to do so. Matthew, I don't know if you've gotten anything yet. And we'll take a pause and do that before we go into the three major alternative dispute resolution procedures.
Great, great. We do have a few things here. Kevin O'Barron is our usual additional commentator here. Lets us know that the rationale for the EJCDC's time limits is to resolve claims and disputes in a timely manner and to evaluate each claim and dispute it on its own merits, and then also adds that the EJCDC has a, quote, work change directive, which is very, very similar to AIA's construction change directive. So you just wanted to add that to the additional comments here. And then also we have a question here from Gustavo, who asks, how does the ADR schedule showed, I think probably on the last one, work in a DB project where the owner and the contractor are the same?
So if you go back to this slide, he's saying how would this work if the owner and the contractor are the same?
Correct.
And I would think one of those steps would just be eliminated, and you would have your designer trying to negotiate with the contractor, and then that second step where you bring the owner in, really it doesn't make sense, because the owner would in theory be at the table already, because the owner is the contractor. Or another option would be, depending on the organization and how the owner and the contractor, how that entity is set up, it may be that you could bring in a third party from that organization that's more of an owner's interest versus a contractor interest.
Right. That's a good point, Doug, and it may be that that very scenario is applicable to one of the alternatives that we're going to talk about in a minute. Because the owner and contractor are one and the same, then it might be more important to try another alternative that may bring more objectivity to the table earlier.
Anything else?
At the moment, that looks to be it.
Okay. And we'll go on and talk about first mediation as one of the three major forms of dispute resolution that are out there. And mediation involves a neutral third party that tries to facilitate between the two parties that are in dispute to help them negotiate a settlement. The mediator does not decide who's right or wrong. He's not making a decision or giving an opinion as to which side's argument carries more weight. He's simply there to try to help the parties resolve the dispute among themselves. So he's a facilitator to facilitate communication and discussion between the two parties. So the process is typically that the parties first have to agree to mediate, and then they would agree to a mediator, and there are different procedures to getting to that agreement on who the mediator will be. Typically, what I've seen is where each side will submit 3 names to each other, and then they review each other's names, and try to, from those names, if you're lucky, you'll get a name that shows up on both lists. If you're not lucky, then you'll have to come together and discuss the 6 folks that you guys had identified and negotiate and try to come to an agreement as to who will be the mediator. So then once the parties identify their mediator and they come to the mediation meeting, the mediator will give an opening statement, kind of explain the ground rules that they're going to be working under, and then each side to get an opportunity to give an opening statement, state their position, state their side of the situation. And then the mediator will facilitate discussions between the 2 parties. He may break up and have private discussions with each of the 2 parties, and then they would come back together and come up with joint negotiations, and then have a closing where either the folks will agree to a resolution or agree that they don't have a resolution. So if they do reach an agreement, the mediator will usually put those provisions in writing. He may ask one of the parties to do that and have the parties write up a binding agreement, probably in consultation with either one's attorneys, and say, if he says, okay, contractor, get your attorney, write something up, write up the settlement agreement, get it back to us, the owner take it to his attorney, look at it, and they'll come to agreement on the language in the settlement agreement and be done. Some of the pros and cons. Mediation typically is less time consuming. The parties can get together. You don't have to worry too much about outside schedules. You just have your 2 parties in dispute and the mediator to deal with. Typically it costs less. The parties typically will split the cost, share the cost of the expenses of the mediator. Parties have more control in the process. They can agree to different ground rules at the beginning, and as I said, they agree to who the mediator is. It's not somebody that's dropped in to the picture that they have no say over. You don't need an attorney. I would recommend that if you do come up with an agreement, that you do draft up a settlement agreement and have your attorneys, both sides of their attorneys, review that, but you don't have to have an attorney while you're doing the negotiations. The procedures are confidential. It's not public record. It's not in a courtroom where the general public can come in and sit down and hear what's going on. It's a private proceeding. Typically it's less confrontational, especially if you get a good mediator that can diffuse and take the emotion out of it and just get the parties focusing on the facts. And you can come up with more creative solutions in that process. It doesn't have to be a one side wins and one side loses. It's be compromises, or if you do this, I'll do that. So you can come up with some different creative solutions. Some cons: once you go through the process, if you don't come out with an outcome, you've paid that cost and you've got nothing for it. So you don't get your money back if you don't come to an agreement. If you don't come to an agreement, then you're probably going to be moving on to the next phase of dispute resolutions. Another con is both parties have to agree to mediate. If one side wants to mediate and the other side doesn't, you can't force the other side to mediate unless you've in your contract written in that mediation is going to be your method of resolving disputes. And another con is the mediator may negatively affect the outcome. You need to be careful when you're selecting that mediator that he doesn't have a bias to one side or the other. You want somebody knowledgeable about the industry and the construction industry, so you don't have to do a lot of education and bringing him up to speed on what the issues might be. And you've probably, there are organizations that certify mediators. You probably want somebody that's been through the process before, knows how to get the parties to come together and negotiate to reach a resolution. Anything to add, Jim?
Well, I would just touch on 2 things there, Doug, that you've talked about. And the the last thing you said, I think in my experience perhaps has been the very most important, which is the selection of that mediator and how you go about that. You know, the parties at the table may know mediators. Perhaps the attorneys that are representing both sides have been through a mediation before and can offer their advice on a proper selection. As Doug said, he has the experience and the knowledge and exposure. I unfortunately have had this experience where the mediator could negatively affect the outcome, and I think is really critically important to find the right mediator by following up with parties who have knowledge of this person's ability, who have experience with them in some fashion, to know that they are in fact a professional at what they're trying to do. As Doug said, there are organizations that represent mediation, and perhaps those are a good place to start to find someone that is able to perform. My second part of the conversation, in my experience, has come at these joint discussions, and one of the things I would add, I realize that when you are at this point that there is disagreement between the parties. I think if you are able to establish some idea of how firmly each side is entrenched, it may help you decide what method to use to try to resolve the difference. If neither side, or one or the other, is absolutely, unequivocally not going to budge, then how you proceed, I believe, may be different. Again, just speaking from experience, if someone comes with the attitude that they've given their answer and there's no room for movement, then you get into this con category of losing your money for no forward progress. And so I think if you can get an idea of the ability to, I guess I'll call it the wiggle room, you know, if you can establish that there is some, then this mediation process is a great alternative.
If anyone wants to share experiences, comments on mediation, we can take a pause and entertain those at this point. I will also add that there are some jurisdictions that will require you to mediate prior to proceeding with litigation. The courts in this country typically strongly favor alternative dispute resolution. I think part of the reason for that is because there's so much litigation out there that they get bogged down with disputes, and some of the disputes are ones that are minor in nature, that they want to encourage parties to work out their disputes before seeking the court's help in doing that. So Matthew, have we any questions or comments?
Yes, we have actually a few items here. So going with Manisha's question or statement, I guess here, how to best deal with a situation where the contractor waits a long time after a construction directive is issued and the work is complete to submit the cost. The cost is provided without sufficient backup, non-responsive, and is non-responsive in providing response to review comments. Let's see here. Complete and non-responsive in providing rationale and additional information for backup. So I guess the question really here I guess is best way to really deal with the contractor who is I guess both dragging their feet and not giving information to back up their claims for information.
I would suggest that be addressed in the contract. Most construction contracts that I've seen have a provision in there that states that the claims need to be submitted within X number of days of the occurrence. You can add language in there if the because a lot of times you occurrence may happen, and you may know it's a change, but you may not know what the dollar amount is. That you put language in there saying the dollar amount has to be submitted within X number of days of the completion of that change work. So you can put time limits in for submission of claims and time limits for submitting the dollar amounts in the claims, and those will be upheld in most courts. If the contractor is not being responsive in terms of supplying you the information you need to evaluate the claim, that again is a contract issue. I know the AIA has it in their general conditions that the contractor is obligated to provide the additional information that the architect, or if it's not the architect, whoever that initial decision maker is, so that he can make those decisions. I don't think it's specifically in there that it says that if you don't provide it, then you waive the claim, but that's something that can certainly be added as a supplemental general condition. So I think there are contract mechanisms that you can use to address those things. If you don't have it in your contract and the contractor is delaying, not getting you the information, work is done, and he can't get the subs to submit the claims, I think as the holder of the purse strings, the owner is in the more powerful position, so to speak, and by just withholding retainage, he can have that as a vehicle to try to help force the contractor to be responsive.
Okay. We had a comment here from Larry, kind of recapping on the previous question from the audience that we had that you all started on. He indicated that he believed it would be legally impossible for an owner contractor as the same person to have a dispute as it is a single entity. So having an ADR process may not be necessary at all. So that was just one thing that was added to the group there. And then we have a comment from... Oh.
You could have a owner contractor that's in an agreement with the designer to design a project, and the owner contractor is building the project, and the dispute could be between the design professional and the contractor / owner.
Okay. Then we have a comment here from Kevin saying, when engaging a mediator or an arbitrator, it is possibly worthwhile writing into the agreement with the mediator and arbitrator that they are required to, 1, render decisions or recommendations in attendance with the contract document, and 2, enumerate the specific reasons for their decisions and recommendations. So that's just a recommendation with the process that Kevin has recommended here as well. Not sure if you have any comments on that as well, or else we do have one additional question.
Just quickly, and we'll talk about arbitration next. Typically, mediation is not meant for someone to come in and make a decision. It's meant to facilitate the two parties to come together and come to their own resolution. So writing in that the mediator is going to make a decision is kind of contrary to what mediation is about. That would be more applicable to arbitration.
Okay. And then we also have from Steven, we have a question. What do you do if the contractor walks off the job during arbitration?
So if the,
I hope you have a performance bond. I think that. Well, Doug, you go ahead. I didn't mean to interrupt.
Well, no, and that's where I was going. If the contractor walks, whether it's because of arbitration or some other reason, that's what the performance bonds and payment bonds are there for. So require, especially on private work, on public work, most of the time it is required, but if you are doing a private work, I always recommend that they require the contractor to supply those bonds. The owner ultimately pays for them, but it's a great insurance policy.
And I think that if you're in a circumstance where you don't have that as all other things in construction, time is of the essence, and so proper notifications to your client saying, you know, we're in a different day now, and I'm going into a mode that wasn't anticipated when we made our agreement. I want to help you through it, but you know, this is through no fault of mine or yours, if in fact that's the case, and proceed forward, you know, with great communication and deliberation and voluminous documentation, so that you don't get caught trying to finance this process, but you also move quickly to find a replacement contractor. And I would expect your contract to require certain notifications of the contractor who has walked off the job. And so I would just finish that by saying document it absolutely exactly like your contract requires, so that you don't overstep your bounds.
Anything else, Matthew?
I'm working with Robert Swan on a question I'm trying to understand, but in the meantime, Larry has an additional follow-up for his question, wondering, should ADR be used at the end of a project when there is a final payment dispute, which is delaying closeout of the project?
It certainly can be. Any of these procedures that we're talking about today, whether it's mediation, arbitration, or some of the others that we will touch on, can certainly be used at the end of a job or at any point during the life of the project.
Alrighty, and then I think I've gotten some information here from Robert. I can try to make his statement here. He was looking to potentially correct or add to the idea that retainage can be used for a purpose here. Indicates here he was stating that you had both indicated that retainage could be held for non-response from the contractor to resolve a claim. The sum will have to help as a punch list item to protect the owner, as opposed to touching the retainage. So I don't know if you have any information of that. I've been working with Robert. I'm going to see if I can unmute your line, Robert, now. Robert, if you want to try talking, maybe you can explain your question statement better than I can.
All right. Did it work?
You can hear? Yep, we can hear you.
Okay. Well, I think you basically read what I wanted to say is you can't, retainage really belongs to the subcontractors and some to the contractor, but what they're talking about is basically if he's not responded and you have a potential claim, you'd have to treat it, in my mind, as a punch list item. You know, you'd have to be aware of it when as you were getting down towards the end of the project. If you had 2 or 3 claims or even one big claim lying out there, you're going to have to get the contractor to understand that, hey, I'm going to have to hold back money because you haven't given me the information I need, or the owner the information he needs to resolve this claim.
And you could also probably use liquidated damages to that effect too, because if you can't close the project out in a timely manner, if you've got liquidated damages set up for completion and not just a statute completion, but closing out the project as well, and closing out a project is what we're going to be talking about at our next meeting next month. But you could tie the liquidated damages to closing out the project, including resolution of all claims.
Yep.
Absolutely. You can also assign values to each of those items that are listed on the punch list, and items like record drawings, as-built drawings, the O&M manuals would carry great value to try and pull together from field measurements if you, in fact, can't get your hands on those from the contractor. So I think, Doug's making a great point that there are opportunities for putting values on that punch list that would be substantial enough to complete the project or cover some disputed amount.
Okay. So the next, I'm locked up again, Matthew. We were going to move on to arbitration. Let me hit escape and see if that gets me back out.
Okay.
No luck. I'm going to go ahead and start talking about arbitration. Matthew, if you can kind of pull it back and send it back again.
Sure can.
Arbitration is an impartial party or a panel of parties that hears the dispute between the two people that are having the dispute, and then they will, unlike a mediator, will render a decision. Arbitration can be binding or non-binding. If it's binding, then that decision of that arbitrator or arbitration panel is final and enforceable in a court of law. If it's non-binding, then either party that's not satisfied with that decision can then proceed on to litigation.
Hey, Doug,
Process.
before you leave, Doug, but hey, Matthew, can you stay? I was just going to say that if you look at that clock right there, this is the fastest arbitration in the history of time, because they arbitrated that case in 2 hours. But what it should have is a date down here at the bottom that when he goes in, it's Monday, and when he comes out without his shirt, it's Friday. Sorry, go ahead.
So assuming that you've agreed to arbitration either contractually in your contract, or if not in your contract, the dispute has arisen and the parties agree to arbitrate, then they need to agree to the arbitration panel. And I'm going to talk in terms of a panel because typically that's what you see is it's a panel of 3. It could be one person. It could be a 2-person arbitration panel, but typically what you see is 3. Similar to how you would select your mediator, you would do it with arbitration. A lot of times, especially if you're having a 3-panel party panel arbitration, you will let each party pick one arbitrator, and then I've seen where those 2 arbitrators will come together and they would select the 3rd arbitrator, or the 2 parties would collectively agree to that 3rd arbitrator. It's similar to litigation. Typically, folks will follow the ABA, American Arbitration rules for filing and proceeding with arbitration. So it is more formal than mediation. They do have rules that you have to follow. It's not quite as controlled as litigation would be. So at the arbitration, each party will present their evidence or testimony, their side of the story, to the arbitration panel. You can have witnesses that can be called and cross-examined. Every arbitration that I've ever been involved with, the parties have been represented by attorneys, but you don't have to have an attorney. The arbitrators, as I said, will render a decision and make an award, and if it's binding, it's final, there's no appeal route, and if it's non-binding arbitration, then either party can proceed with litigation if they are not satisfied with the finding of the arbitration panel. Some perceived pros and cons. Arbitration can take less time. Jim commented on the first slide about the timing issue. Time can be a pro and a con. The con would be the issue in coordinating the schedules to get the arbitration panel and the 2 parties all in the same room at the same time. So it can take less time than litigation, but it also, depending on working out schedules, can take more time, because often the arbitrators are coming from different parts of the country and trying to work out schedules. You're going to meet Monday, Tuesday, everybody's good for that, and then somebody's got to fly off because they got something else they got to do, and you can't get together until the next week. So there's a lot of starting and stopping and coordination of schedules that could be a con, as well as time being a plus by typically taking less time than litigation. It can be less costly, it can be less expensive. A big plus to me is that when you're presenting your case to this panel, you're dealing with experts in the subject matter. You're typically dealing with people that know the construction industry. You're not dealing with a jury of your peers that are the general public, or a judge that has no knowledge of construction and how that process works. A pro, if it's binding, can be that there's no appeal. There's that certainty that you know once we're done, we're done. That also could be perceived as a con. And the proceedings here, again, are confidential. It's not open to the public. As I said, it's more informal than litigation, and you have a choice or say in selecting that arbitration panel, that decision maker. You're not at the whim of the court system where you don't know what judge you're going to get, and you don't know who's going to be on your jury panel. Cons: if it's non-binding arbitration and a party does not like the outcome, they can proceed to litigation, in which case it's going to be more costly than had you just simply went to litigation to begin with. Again, you are paying this arbitration panel. Each party typically splits the cost for the arbitration panel, and that's not just paying for their time to be there, especially if they're coming from different parts of the country. You've got to pay for their travel and meals and stay while they're at your location. So if it's non-binding, you've paid for that arbitration, and then you're going to be going on and paying for litigation. If it is binding, a con could be that there is no appeal process. So you are committed to live with whatever that panel has decided. It has been said that arbitration panels have a tendency to split the baby. They'll listen to both sides, and instead of saying, okay, Mr. Owner, you're right, or Mr. Contractor, you're right, they'll say, well, there's some gray in here, and so we're going to split it 50-50 or 60-40 or some manner like that, so that there's not necessarily a true winner. It's a splitting of the baby type of deal. Talked about schedules. You can have issues with getting everybody on the panel's schedules to align so you can proceed in a timely manner. The rules of law are not binding on arbitration panels. There are rules of evidence and rules of laws that the courts are going to stick to, that the arbitration panel does not have to follow. And that could be a con if there's a technicality that would have worked in your favor in an arbitration proceeding. They will more than likely ignore that technicality. Kevin's comment previously about making sure that they stipulate what their rulings are, what their findings are, is important, especially if it's non-binding, so that when you go to court, that the court has that information so that they can use it when they're making their determination and decisions. Discovery is a process in litigation where you have to show the other side your hand, basically. You get to ask questions, you get to have documents provided for you. With arbitration, you can agree to limit that discovery, which can also save time and cost, especially in this electronic age. Electronic discovery, when you're going and looking at hard drives and emails and issues like that can be very expensive. Jim, anything to add?
Well, I would just say a couple of additional things that you've already pointed out that I think are really important. I think arbitration, any of these alternative methods tend to be much faster than choosing litigation, just for the simple reason that there are typically fewer individuals involved, and it can move at a quicker speed. So while arbitration might, as Doug said, might have to get some scheduling done, you're maybe able to schedule it better than going through court. One of the things that I would suggest that you think about, and I personally perceive this as a positive thing, the arbitration process allows for personality. And let me describe that by saying that if you are in a situation where the other side is just being as persnickety and difficult and unagreeable as they can possibly be, that comes across to you, it's going to come across to an arbitration panel as well. And as Doug said, they're typically experts in the field, so they get it, they understand. They know that no one's perfect. They know that mistakes are made. They've done this before. And if someone is just being, ornery for the sake of being ornery, that's going to have an impact. And I'm not so sure that's a bad thing in the arbitration process. So, I just think when you agree on the right experts, this can be an excellent way to get something behind you and move on. That's all I had, Doug.
Matthew, any comments on arbitration from our audience?
Kevin would like to add something to the cons, saying some arbitrators render decisions not in accordance with contract documents, and sometimes they present no written reason or rationale for their decisions. So that comes from Kevin. And then we have some follow-up from some questions that we had earlier still from other people in the audience indicating that they thought that the ADR was used to resolve disputes between the owner and contractor during construction, not between the architect and owner, even though ADR may be the owner-architect agreement. In other words, despite a dispute between the owner and architect during construction should not necessarily affect the progress of the work by the GC. And just want a clarification on whether or not you're correct in that statement.
Well, alternative dispute resolution can be used to resolve any dispute between any set of parties. It can be the contractor, owner, it could be the owner, designer, it could be the designer and one of his consultants. So it's just a vehicle for resolving disputes. It's not specific to a owner contractor situation. During construction, if there was a dispute that arose between the owner and the designer, without creating a bunch of hypotheticals, I think that I could foresee a situation where that could hold up the contractor quickly. Say there's a dispute, the owner's not paying a design professional and they're disputing over money or errors on emissions or whatever, and then the designer says, well, I'm just going to stop work. I'm not going to answer any more RFIs and review any more submittals, and the contractor's sending this stuff in and can't proceed with his work because he doesn't have answers to his questions or his submittals approved. And that would be a situation where a dispute between an owner and a designer architect can delay the construction process. I'm not sure if I touched on everything that was in that question, but I'll stop there and let Jim join in.
Yeah, I think you covered it. So I don't have anything to add.
Anything else, Matthew?
That is it at the moment.
We're going to move on to litigation. That's where a judge or a jury hears a dispute and renders a decision, and those decisions are based in law and in fact. It is not too atypical from what you see on the television court shows. The process is one of the other parties sues, they file a complaint. Each party will present their evidence, testimony, they can call witnesses, cross-examine witnesses. Once all of the evidence is heard, then either the judge or jury, depending on whether you're having a jury trial or just a judge or bench trial, they would be the finder of fact, and either the judge or the jury would render a decision. If it's a bench trial, then it's going to be the judge rendering the decision, and there's no jury involved. If it's a jury trial, then the judge is there to enforce the rules, and the jury is the finder of fact, and the jury renders a decision. That decision may be appealed if the judge made an error. There are some instances, and without going too deeply into legal aspects, where you might have an automatic appeal, but typically to appeal a decision during a litigation, there has to have been an error made by the judge during the course of the trial. Either he admitted evidence that he shouldn't have admitted, or didn't admit evidence that he should, or something like that. Pros and cons. A big pro is that it is a motivation to settle. People do not like going to court. It is not a pleasant experience, and it might get folks to come to the table and sit down and negotiate a settlement to avoid having to go through that process. It is expensive. That's a con. That's not up there. Well, yes, it is up there. It is expensive. Paying attorneys, as that first slide shows, it's not cheap. A pro is that a decision will be made. It's not like mediation, where you go through the process and you may not come out with a solution. You definitely get a decision at the end of the trial. That decision is enforceable. There is a sense of certainty with it. There's expectations that you can kind of rely on, looking at similar situations in other cases. There's precedents, so you have some sense of where you might end up. Discovery I talked about before, where you have to show your hand so you know what the other side, what they're going to present. There is rarely times that there are any surprises or aha moments. That's unlike what you see on TV. You typically know what's going to come out evidence-wise from the other side. And there are set known rules that you have to follow. Those procedures are there, and you know what those are, and you're not at the whim of a arbitrator that might say, okay, well, we're going to ignore that rule. We want to hear that evidence anyway. Here that you have that sense of certainty. Cons, time. It can take several months or even years to resolve a dispute. You get into the process where either side is filing motions for this or motions for that, and stays and all kinds of pre-trial stuff that happens that can take a long time. Talked about it being expensive, all of that work that those attorneys have to do to file all those motions. You got to pay for all of that. It can put a strain on your business and your relationship, just knowing that you're going through that process and waking up every day for several months, a year or so. I've still got that court case out there I got to deal with. So it can also put a strain on the relationship between the parties themselves. Whereas if you go through a mediation and arbitration and come to a more friendly type of an agreement, then that business relationship may be able to still exist and be healed, where with litigation it's probably not going to heal. The decision is made by non-experts, which is another reason why it takes time. So you're talking to a judge or a jury that knows nothing about the construction industry, and you've got to spend that time educating them and bringing in experts to tell them, well, this is what industry standard is. And then the other side is going to bring in his experts. So you're educating the people that are making the decision as to what your industry is about. And these proceedings are public. People come in, walk in off the street, sit down and hear them. So in a sense, you're airing your dirty laundry out there for the world to see. And if it does go to an appeal, then all of those appellate court decisions are published. And then you've got that history that's there for the world to see forever. Any comments, Jim?
No, I don't think so, Doug. I think you covered it. I can't think of anything else to add.
Well, it's 1 o'clock. I'm going to hurry through so we can wrap up. There are other options for dispute resolution. Judicial review, you can hire a private judge or a lawyer to sit and hear your case as opposed to going through litigation, arbitration, or mediation. There's little mini trial setups where, again, you get a neutral party hearing the case. It's an expert in it. They're able to render decisions based on case law, so they usually follow more strictly the rules of law than an arbitration might be. A dispute review board, members of the construction industry that come together and convene, and you can have them systematically throughout the life of the project review the project status, issues that come up, so that they're more involved day to day. Well, not necessarily day to day, but they're more involved in the happenings of that project over the life of that project, as opposed to just being called in to hear the single dispute. I've also seen where you have, if you're just having a dispute, you might just get the higher-ups of that company to come together and sit down and discuss it and resolve it, so you don't have the owner's project manager and the contractor's project manager say that we've been butting heads and get emotional and don't want to budge off their positions. You take it up within the company so you have a fresh set of eyes to hear it and resolve the issue. So those are...
I was just going to say, Doug, that option that you just discussed is probably, in my experience, the absolute best first step. And if you think across other types of things that people do, that having a calm and semi-uninvolved third party step in and consider something rather than those folks that are in the heat of the moment makes great sense, and from my experience has been a great method to make a decision quickly and move on from where we are stuck to the next thing. And as Doug said a minute ago, it maintains a relationship and allows you to move forward and complete the project.
Real quick, Matthew, anything from our audience before we wrap up?
No, we seem to be quiet on this front.
And we thank you for joining us.
Alrighty, well, thank you again, everybody. Again, we look forward to seeing you next month or in future meetings. You may now disconnect and go back to your workload or wherever you might be going today. Thank you.